back, everybody. Thank you for your patience today. Thank you for the staff for working incredibly hard all day. We now have some motions on the table. We went through the bill earlier today. We talked about all the agreed upon language. And so I'm going to move the adoption of the Senate sections. R1, Section 1, R2 through R6, Section 1, R14, Section 5, lines 10.3 to 10.4, R14, Section 5, lines 10.5 to 10.17 as amended, R15, Section 5, lines 10.18 to 11.12, R17, Section 5, lines 12.3 to 12.16, R18, Section 5, lines 13.5 to 16.30 as amended, R24, Section 6, lines 17.13 to 17.22, R26, Section 8, lines 18.14 to 21.8, R31, Section 10, lines 23.15 to 23.20, R13, Section 10, lines 23.28 to 24.2, R36, Section 13, lines 28.9 to 28.25, R13, Section 13, lines 28.26 to 30.18, R39, Section 14, lines 31.2 to 34.26 as amended. R43, Section 14, lines 35.22 to 35.24. R43, Section 15, lines 35.27 to 39.6 as amended. R47, Section 15, lines 39.24 to 41.15. R49, Section 16 and 17, lines 41.16 to 44.2. R52, Section 19, lines 45.29 to 46.5. R53, Section 19, lines 46 to 13 to 47.7 as amended. R58, Section 25, lines 51.15. R58, Section 26, lines 51.26 to 53.12 and 53.18 to 53.19. R68, Section 33, lines 62.15 to 62.22. R69, Section 35, lines 63.13 to 63.22 as amended. R17, sections 37, 38, lines 64.15 to 65.1, and R77, section 12, line 68.1 to 68.4. All those in favor say aye.
Aye.
All those opposed? The motion prevails. Senate sections are adopted. Representative Richardson.
Thank you, Madam Chair. I move adoption of the House sections. R1, Section 2, R6, Sections 5 through 7, R11, Section 9, lines 10.17 to 12.13, R13, Section 9, lines 12.14 to 12.16 as amended. R13, Section 9, lines 12.17 to 13.17 as amended. R14, Section 9, lines 13.18 to 14.30 as amended. R16, Section 9, lines 15.13 to 15.30. R17, Section 9, line 16.14 to 16.32 as amended. R24, Section 10, lines 24.1 to 24.11. R25, Section 11, lines 24.23 to 25.17 as amended. R29, Section 14, lines 29.6 to 31.9. R31, Section 14, lines 31.17 to 31.23. R32, Section 14, lines 31.30 to 35.26. And R36, Section 17, lines 36.25 to 36.27. R38, Section 18, lines 38.5 to 39.19 as amended. R42, section 18, lines 42.22 to 43.18 as amended. R46, section 19, lines 46.33 to 47.24. R52, section 23, lines 52.28 to 55.30. R53, section 23, lines 54.8 to 54.14. R61, section 34, lines 63.27 to 68.17 as amended. R67, section 37, line 69.27 to 70.19. R68, section 37, line 71.7 to 71.19 as amended. R68, section 38, line 71.20 to 72.2 and 72.13 to, I think there's a typo here. Does that go to?
Okay. Say that. Probably 72.
I think there's a typo here. 72.13 to 68, section 38.
Yeah, 73, so 13 to 50, 72, 15.
Thank you. Okay, I'll restart that. R68, section 38, line 71.20 to 72.2 and 72.13 to 72.15. R71, section 40, line 73.19 to 73.21 as amended. R71, sections 1 through 5, line 73.22 to 76.5 as amended. R74, sections 1 through 11, lines 76.21 to 78.29.
Very good. Any questions? All those in favor say aye. Aye. All those opposed? The motion prevails. Next up for consideration, we have some further amendment with new language. I'll bring your attention to the A87 that has been posted publicly. And you should have a handout available to you. What this amendment does is that it makes sure that if someone does take intermittent leave, that they are entitled to their full amount of leave and that their next amount of leave can be taken in a block time. It also adds languages so that people are not penalized essentially for asking for leave. Any questions? Can I get a motion to move the A87?
Madam Chair, I wanted to clarify, can you give me the line?
You're it's the wrong amendment. It's the 887.
All right, the secondary one, I apologize, it was on another piece of paper. So I had a question earlier, and I know I had spoken to Chair Richardson about it, about the intermittent leave continuously, and we took out the limit. There was a.
No, we still have that language in the bill.
Okay, all right, thank you so much for that confirmation.
Madam Chair, I'll move the A87.
All those in favor signify by saying aye. Aye. All those opposed? Motion prevailed and the amendment is adopted. Next, we have the A23-0172, which is also available for handout. Do you want to walk over it?
Yeah.
Ms. Doyle-Fontaine, if you could.
Yes, Madam Chair, I do want to go, just quickly go back to the motions that you all made. There might have been a couple of little things that will be covered by when we make our technical changes, that may have been a few lines here and there that were not off, maybe in accordance with what we did earlier.
Okay.
So I just wanted to, that'll be part of your motion at the end to make any technical corrections that didn't quite conform with some of the lines in those motions. And I just want to make sure everybody's aware of that. So get that off the, get that on the record. So the A21-0172. So the lines 1.2 to 1.6, this deletes the language that's on the Senate language right now in R14 that talks about seasonal employers. And instead, then on line 1.6, this inserts that employee does not include seasonal employees as defined in subdivision 35. So it'll just delete the language that's currently in the Senate side regarding that and inserting this language. Then on R18, from lines 1.7 down to the 1.
Ms. Fontaine, could you just read the number of the amendment?
Oh,
for
I'm sorry.
clarification?
Madam Chair, we are looking at the A23-0172.
Okay, thank you.
Okay. Did I say 071? That was an earlier amendment. My apologies. I'm looking at notes from my earlier one, so it lines, if they're off, that's the reason.
I just wanted to correct for the record.
Yes,
No worries.
thank you, Madam Chair and Representative Edelson. So from lines 1.9 down until 1.25, this will add a definition into the definition section for seasonal employee. Again, and all of this language that's contained within this amendment did come from DEED in collaboration with members on this conference committee, as well as probably some input from MMB and other agencies. So that would be the new definition of seasonal employee. Then on line 1.26 down to 1.30, this would replace language that's currently contained in the Senate language, and we discussed this earlier, that we are going to be getting some new language surrounding procurement for the Department of Employment and Economic Development. DEED has tightened up the references to statutes and has tightened it up to only the relevant statutes that, and not the entire chapter. So now this is to really the statutes that they feel they need the exemptions from, just for the purposes to get the chapter and the program up and running. And then, of course, they will be subject to them once the exemption goes away. Then we turn over to page 2, lines 2.1 to 2.8. It addresses seasonal employment denial for benefits. And it states that they're denied while their applicant is a seasonal employee. And then on lines 2.9 to 2.31, this provides new language for an appeals process. Again, this came from the Department of Employment and Economic Development. This clarifies some of the appeals process and updates some terminology regarding benefit, no longer being a benefit judge, it would be a hearing officer, and just making making it be able to work a little bit better for the department. So it's updating some terminology and the process there. Then over to page 3 of the amendment. This is on R48, again to the Senate language. This adds a couple of new subdivisions to the private plans, adds provisions and language regarding if a private plan by an employer that has a private plan, if they want to terminate their plan that they have, and how that would interact and what kind of notification that the employees would need to receive if the private plan was terminated. So this language on these lines includes how that would work and how it would be approved. On line 3.2, 3.21 to 3.22, this would add seasonal employees to the wage reporting piece. So we just need to include that now that seasonal employees are included for the wage reporting. On line 323 to 3, let's see, over to, it is stapled bad, so I kind of have to figure this out here, to 4.23. This, so currently, the bill contains language regarding federal income tax withholding. Now, with this amendment, it adds language to state how state taxation, how that would affect. So subdivision 1 on lines, again, I'm going back and forth between my two versions here. Subdivision 1, the income tax withholding, the federal income tax withholding, that's currently in the bill. There were just a couple little word changes there, but subdivisions 2 through 7 are new language coming in here. And like I said, it just, you'll see on line 3.29, it says benefits received under this chapter are subject to state income tax. And then it talks about how applicants are informed about how they are subject to federal and state income tax and withholding, et cetera, correction of errors, effect on payments, et cetera. So that is language on state income tax for the benefits. Then let me see, I need to go over to the next page. Madam Chair, continuing then on line 4.24, this is on R58 of the Senate language. We are deleting a subdivision. And a lot of these places, it was more difficult to do a page and line, so we're deleting some subdivisions instead of doing it that way. I'll try to point out the language that's the new that was inserted by deed. I've highlighted that on my copy here, so hopefully that helps everybody a little bit. So on line 4.26, like I said, it's language about overpayment because of misrepresentation. And on line 5.2, you'll see that the penalty assessed would equal to 15% of the amount overpaid. So that's where that 15% is there for the overpayment. Then on line 5.4, it talks about an applicant filing an appeal within 30 days after sending the determination. So they would have those 30 days to file an appeal. And then paragraphs D, 5.8 to 5.14 we're already in the section, so that's existing already within the language, except for on line 5.13, the department is authorized to issue determination of overpayment penalty under the subdivision. It was 12 months and now it's 24 months. So that's been pushed out a little bit. And then the subdivision 3 theft from lines 5.15 down to 5.29, that is all new language. So it talks about an individual is guilty of theft and it cites a criminal statute if they try to obtain benefits, through false statements, et cetera. And then at the bottom, it does provide for, this would be a gross misdemeanor if the fraudulent activity is 500 or less, and it's a felony if the fraudulent activity is over $500. So that is being added to this, in this amendment. Then on line 5.30, page 5 of the amendment, we are clarifying that on this particular line, it's not referring to an employee, but it's the commissioner. And then we're deleting lines 13 to 15, which regard benefit overpayments still, and some of this interaction here. And we're adding a new subdivision regarding court fees and collections. This would make it clear that if the department has to go to court, that any court fees overpaid for benefits, penalties, or interest, the amount of the court fees would just be added to the total amount due. And then also talks about if it's similar if there's a bankruptcy or some sort of offset for tax refunds. Also talks about how they would collect those fees, and that had not been contemplated previously within the bill, so it's being added here. Then on line 6.14, we have language starting here that is related to the lien levy set-off language. This is on the Senate side that was discussed earlier. So this will simplify filing of lien notices. I think it's removing some Secretary of State requirements. So that is from lines 6.14 down to 6.23 of the amendment. Then on line 6.24 down to 6.29, it is language about the annual reports, and this would add annual report information on seasonal workers. It looks like we had to delete some lines, and then the only new language is on line 6.28 to 6.29 of the amendment, talking about information on collecting about those seasonal employees. So I just want to point that out. Then on the bottom of page 6, lines 630 on House, or on R68 of the House language. I'm sorry, here, I really messed up with this. I'm gonna have to go up here. This is language that's being added to the notice requirements. And so if an employer has seasonal workers, they do need to issue each seasonal employee a notice that the employee is not eligible to receive paid family and medical leaves while the employee is employed, unless they meet that definition. So this would just require employers to provide that notice requirement to the seasonal employees. Then I think the next change we have, and again, cannot find this on my menu here. I am so sorry. It is all turned around here. My apologies. I'm just trying to find my place here. Okay, Madam Chair, my apologies. I found my place. Okay, so on line 7.10, on R69 in the Senate language, this was discussed earlier today. We already included this. This is about the severability. We're just belts and suspenders, including if it's something of interaction with state law in addition to federal law. So we already included that in earlier discussions. Then on R70, the Senate language, we are deleting the section on small business assistance grants, but we're replacing it. And I will go quickly through a few of the little changes that DEED has made to the small business assistance grants. So on line 7.15, it is being added that the business, they already have to have 30 or fewer employees, but now we're adding less than $3 million in gross annual revenues. So that would be an additional qualifying for the small business assistance grants. Then on line 7.18, including that the grants may also be used for to increase another existing worker's wages in addition to what was already allowed to hire a temporary worker. Then on line 7.20, the maximum grant is now set at $6,000 per eligible employer per calendar year. Then on line 7.21, it says that new languages that grants may be used to hire temporary workers or to increase wages. So that is clarifying to increase wages part. Let's see, the other language is on 7.26 to 7.27 regarding the amount of grant requested is less than or equal to the additional costs incurred by the employer. Then on line 7.29 to 7.31, this is new language regarding that the applications need to be processed on a first received, first processed basis within each calendar year until funding is exhausted. And then after it's exhausted, it clarifies that those applications are not eligible for reimbursement. Then in paragraph H, it just clarifies that unless additional funds are appropriated, the grants are maximum of $5 million, and that clarifies that this is coming from the Family and Medical Leave Benefit Insurance account. Then I think the last piece we have here is some changes to the actuarial study. And what is being changed here is that the Commissioner of Deed is going to work in consultation with the Commissioner of Management and Budget, and that the premium rates must be adjusted if the study indicates that needs to happen, but any adjustment would still be subject to the 1.2 annual premium, or the cap on the premium percentage. So that's the maximum premium rate. And then in the actuarial study, it needs to be provided and filed with the Legislative Reference Library. And then we have some additional changes here. The amendment is also deleting, which we discussed earlier, I think we adopted like sections 37 and 38. This was the stakeholder group on the Senate language, and also the creation of the direct care provider account. So we're deleting those with this amendment. And then on page 9 of the amendment we're looking at right now, on R77, we would delete the current section 12, which is the $20 million that would be appropriated to the direct care provider account. And instead, this section would be inserted, and it would, again, it would still provide $20 million. It would be appropriated from the Family and Medical Leave account, which that's not necessarily specified here, but I would like to, if we could, on line 9.12, after appropriated, insert is appropriated from the Family and Medical Benefit account? Madam Chair, Family and Medical Benefit account, to the Commissioner of Human Services. Now, you may also realize, and this is be part of the technical changes that we're going to be making. There is already an appropriation to the Department of Human Services. I spoke with Ms. Noldner earlier, and we will figure out kind of where this goes. She's okay with it going right here. It should probably go above the transfer, that's section 11, so we might put it at section 10. I just want to let you know that it might be somewhere else, but it will be included. Again, this is to take the place of the mechanism that the Senate passed, but this would now be run by the Commissioner of Human Services to provide reimbursement through an existing mechanism within the Home and Community-Based Workforce Incentive Fund. So it will go that way instead of as the way proposed by the Senate. So I can't really speak more to this concept, but this is my understanding as it's coming into this amendment. So with that, that's my lengthy description of the amendment. Hopefully you understood what I was saying, and if you have any questions, let me know, please.
Okay, so should we make an oral amendment then to the?
Madam Chair, yes.
Okay. So the oral amendment, I'd like to make a motion to, on lines 9.12 of the A23-0172 amendment, after the word commissioner, to add from the Family and Medical Benefit Insurance account. Would that be correct?
Yes, Madam Chair.
Okay, any questions about the oral amendment? Seeing none, all those in favor say aye.
Aye.
All those opposed? The oral amendment is passed. Any questions about the amendment as amended? Representative Edelson.
Thank you, Madam Chair. I just want to thank you for the section on direct care providers and working through that language so that we could get clarity. That was the line 9.10 to 9.21. This really will clarify the reimbursement of direct care workers, which include long-term care employees. So thank you for that.
Thank you. Other questions? Anybody?
I have another motion.
Mr. Lafontaine?
Madam Chair, I do have another quick motion that I believe MMB and some of our fiscal staff would like to be made. Earlier, it's on page R57, and earlier, we adopted the section 24 on the Senate side regarding administrative costs. And the desire is to, on page 51, line 4, to delete lines 4 and 5. And then on line 51.6, delete everything before the period. So because of the program not being effective now until January 1, 2026, this sentence is no longer needed. And they would just like that to be removed, Madam Chair.
Okay, so I think we need to adopt the amendment and then make a
Right.
motion to orally amend the bill. So on the motion to adopt the A 23-0172, all those in favor say aye.
Aye.
All those opposed? The amendment as amended is adopted. And then if I could get a motion to strike lines 51.4 to 51.6 before the period on R57.
So moved.
Any questions? All those in favor say aye. Aye. All those opposed? The motion prevails.
And then, Madam Chair,
Yes.
when you're ready, we would like to adopt this effective dates sheet,
Yes.
please, Madam Chair.
So next up, we will have, are those handed out? You guys have the effective dates with you?
No.
Okay. In that case, yeah, so we'll get those scanned and posted. In the meantime, we'll move on to the. I'll do that at the end.
She's on.
Again?
Yeah, we adopted it, yes.
Okay. So we have fiscal online, if they want to do just a brief walkthrough of the changes that we made. It's the fiscal chart that is dated 5/13/23, 11:27 a.m.
Just, Madam Chair, can you hear me?
Yes.
Yep. The timestamp of the spreadsheet is 11:27 a.m. The appropriations to deed on line 25 will stay at 50,938 in fiscal year 24, 71,357 in fiscal year 25. And the base will change. Have to find, well, to cover the 6-month period where the program isn't started yet, but the new fiscal year, there will be a base set. And I can't see where that is, so that will change. And commerce will stay the same in fiscal year 24 and 25 at 376 in fiscal year 24, 316 in fiscal year 25, and then the base will be set at 64 to cover those 6 months of administrative cost. Same with the Department of Labor and Industry. On line 37, the fiscal year 24 and 25 will stay the same, and then there will be 6 months worth of administrative costs covered with the 366,000 in fiscal year 26. So the rest of the appropriations will stay the same as we presented them earlier today. Yeah, and then the footnote on line 92 describes the change that was made this afternoon. If there are any questions, I can take them.
Thank you so much. Any questions? Seeing none, can I please get a motion to move the revised spreadsheet?
So moved.
All those in favor signify by saying aye. Aye. All those opposed? The revised spreadsheet is adopted. Next, did we get the effective dates passed out? Not yet?
What's the time stamp on the spreadsheet?
11:27. We wait? It's being printed as we speak.
Madam Chair, you could make the motion for directing nonpartisan staff, just the technical motion, if you'd like.
Okay, so,
It's a long paragraph, you could read it out.
I move to direct nonpartisan staff to prepare a conference committee report and incorporation of the spreadsheet. And I also move that the nonpartisan staff are empowered to make technical and conforming changes to the language approved by this conference committee in order to reflect the intent of this conference committee. All those in favor signify by saying aye. Aye. All those opposed? The motion is approved. And now we wait. But we're just adopting the effective dates, which are very straightforward. While we wait for that to be handed out, does anyone want to make any closing comments? Representative.
Thank you, Madam Chair. And to you and to Chair Richardson, I want to thank you for your tireless advocacy on behalf of Minnesotans as elected officials and in your work outside of the Capitol. I'm also grateful for the collaborative nature of this work, both including conference committee members directly in deliberation, but also engaging with outside advocates, the business community, and minority members. I've had multiple meetings with my local chamber and business owners on this topic, and particularly important to them was flexibility for small businesses, the option for intermittent leave, and capping the total number of weeks available annually. These accommodations, as well as an exclusion for our state's seasonal hospitality industry, have all been made in the conference committee report as amended. I also serve as the vice chair of the Commerce Committee in the House, and after conversations with Commissioner Grace Arnold and her staff at the Department of Commerce, the insurance industry, and Representative Dave Baker, I'm happy to see the language included that allows third parties to offer private PFML plans, which will give businesses additional flexibility as we move into implementation. That's a provision that is very important to our minority members in the House, and it's a new option for our insurance providers to bring to market. Beyond the changes that we've made in partnership to support the business community, this bill is going to make an incredible impact on Minnesotans. As a foster, adoptive, and biological mother, I know well just how precious and important the opportunity to bond with your children is. Mothers who wait at least 12 weeks to return to work after childbirth have a lower likelihood of depression and stress. Fathers who take at least 2 weeks of family leave are more likely to help and carry out childcare-related tasks when children are young, which is in turn can increase those chances that the birth parent is able to return to the workforce. The impact on these children is equally important. Sometimes we do have the tendency to look at policy in silos, but policy like paid family medical leave does not impact the lives of Minnesotans in a singular way. If we only look at the bonding leave option, research has shown that this can improve family life, the physical health of infants and birth parents, the postpartum mental health of mothers. It allows foster and adoptive families to build trust and intimacy. It has economic benefits like helping women return to the workforce, usually increasing household income and creating better outcomes and savings in our healthcare system and our economy. Minnesotans care for one another. This paid family medical leave program will help us get every child in Minnesota off to a great start. It's an investment for Minnesotans by Minnesotans, and it takes us one step closer to being the best state in the country for kids and families. I'm so proud of the work that we've done, and I'm excited to vote in support of this conference committee report. Thank you.
Thank you so much. Other comments or thoughts?
Sure.
Senator.
Sure. And I will also echo all of those things and thank both of the chairs. I have spent an awful lot of time on a bill that I was not an author of, probably more so than some of the bills I was authors of. And brought some of the same concerns to on my side, Senator Mann, and she has been a great partner in working on this. And I know, firsthand from job experiences that I've had when I've seen my female coworkers who, when they've gotten pregnant and they've had that decision, what do I come back to work? And more often than not, they chose to not come back to work. And then they were out of the workforce. And then it meant we had to find a new replacement for them, permanent, and go through the whole training process over again, which is a cost. And it's a cost of trying to find the replacement, the full-time replacement for them. So I just know from my firsthand experience. And also, I will say, I had a real luxury when our child was born that my wife stayed home and I just happened to work. And then magically, we transitioned and she got a job and I got to stay home. And I wouldn't give up those couple of years at home with my son for anything. And that's a long period of time. And this isn't that, but this is a huge help to so many people. And I think the outcome on those kids when they have that time with a parent that they can bond with is just outstanding. So this is going to make a huge difference in people's lives. So
Thank you.
thanks.
Okay, we have the spreadsheet with the effective dates been posted in front of you. Any questions about the effective dates?
Madam Chair, I have a quick clarifying question.
Yes.
So currently in the bill, it states on many of the sections, something along the lines of, except as provided under section that, whatever, 41 or changed. This section is effective July 1, 2025. I'm not certain whether or not that except as provided under section clause needs to be now included in all of those effective dates, or if we are just going with this is effective for, benefits as of January 1, 2026. So I'm not certain if there's an advocate here or someone, or somebody can clarify, because here it just says proposed effective date. So with that, we would assume that it just should, this section is effective July 1 or January 1, 2026. So unless we know otherwise, that's what we would do. Madam Chair. I believe I see a nod that it would be okay to just say this section is effective and put these dates there.
Yeah, I would agree with that. Okay. So do we need to,
No, just clarify that the effective dates are just as the dates that are provided in the proposed effective date, with
Okay.
no other language necessary.
okay. Do we need a motion for that, or we just accept this as is and that goes in?
Yeah.
Okay.
And I have one more point.
Yes, please.
And this is on an earlier point. I just want to go back and just clarify for the record that there were some earlier provisions when I did the walkthrough of the side-by-side, and I said that these are placeholder, we're leaving them open. Then we adopted the amendment. I want to make clear that as you're adopting this, that you've adopted the amendment, you're also adopting those sections that we did not adopt earlier and might not have been on your sheet. So those are also being adopted with the amendments being incorporated. I just want to make that clear.
Very good.
Okay, thank you, Madam Chair.
So a motion to move the effective dates.
So moved.
All those in favor say aye. Aye. All those opposed? The effective dates are moved. Did you have anything you wanted to add?
Thank you, Madam Chair, for the opportunity to say a few words. I wanted to start with some gratitude, with thank you. I've been carrying this bill for a number of years, and I have been working with many people to get to this point. And so the list is probably too long for me to identify each person independently. But I just want to recognize that the work that I have done on this bill over the last several years was followed by the work that was done by many others that were carrying this bill before I took it on. And it took a village to get to this point. And so I just want to lift up the good work that has been done, and to also lift up the number of voices that are captured within this bill. Not only from members around this table, but from families, from advocates, from the departments, the business community, the insurance industry, the construction field, labor, the faith community, nonprofits. it is a collection of the diversity that our state reflects. And I also just want to lift up that it's a good day in Minnesota because this is something that Minnesotans want. And it was not lost on me, the recent poll that just was done here in Minnesota. The vast majority of Minnesotans have been waiting for paid family and medical leave. And I know we've talked a lot about how this can be an important way to keep folks in the workforce, particularly women, and recognizing that between 2016 and 2020, over 70% of pregnant Minnesotans were in the workforce. And the majority of them had to take some form of unpaid leave. And we recognize that there are so many benefits that come with having access to paid family and medical leave. The maternal mortality rates decrease, infant mortality rates decrease, hospitalizations decrease, dependence on long-term care decreases, dependence on social programs decreases. People stay within the workforce, and businesses don't have to continue to cover the cost of that constant turnover when people are in and out. But beyond that, I am just so proud because I know this bill also reflects the humanity that we as Minnesotans know that each other deserve, the ability to care for ourselves and the ability to care for our loved ones as well. And I know that not everyone got everything that they wanted within this space. But the goal that I had when I took on this bill was to build a plan that would cover the most Minnesotans because we have a history of leaving folks out. And I think it's important that we ensure that we are being as inclusive as possible. And I also like to thank you, Madam Chair, as well for being such a great partner within this work. And wouldn't have wanted to be on this journey with anyone else. So thank you for the opportunity to say a few words.
Thank you very, very much. Thank you, everyone, for being here today. Thank you, everyone, for all the incredible amount of work you have done just today alone, but really in the last many, many months and years in some cases, and the advocates for all their work. We are going to offer something that is going to change the lives of people, and it's going to make living easier, and it's going to take away burden from people. And we could not do that. We would not be sitting here today if it wasn't for every single one of you. So thank you very, very much. Minnesota thanks you. And we are not quite done yet. We have a little bit more to go until we cross that finish line, so we'll keep up the good work. And seeing no further business before this conference committee today, we are adjourned.